Hey, everybody. Happy Tuesday night. It is Kevin here, and we've got another YouTube live stream here tonight, and got an awesome lineup here tonight for the show, and I really appreciate all of you guys for checking us out this evening. But first, we got to talk a little bit. I'd be remiss if I didn't talk a little bit about my beloved Redskins. Because we talked about it last week. So psyched after the Detroit win, but they went into Philly and unfortunately got decapitated. However, very proud of my team. And for you Washingtonians out there, I know that there's a lot of excitement around the Washington Redskins / Commanders. So I think it really depends upon your age, what you call them these days. But anyways, let's talk a little bit about the overview for tonight. So my guest is Matt Alegi. He's with the law firm of Shulman Rogers in Potomac, Maryland. And Matt is a partner with Shulman Rogers, and he is a real estate attorney, real estate expert, go-to guru when anything that you need to talk about real estate law. So one of the things we're going to talk a little bit about is the whole NAR settlement class action lawsuit that occurred last year. Very big news last year. A lot of changes that occurred in between March and August of last year. And, with the election and now with the inauguration and all the holidays, a lot of people kind of forgot about it. But, here we are entering the spring market. So we're going to talk a little bit about that. Try not to bore you to tears on it, but do want to let you know a little bit about some of the changes that have occurred. And then next, we're going to get into some of the things that Matt sees that comes across his desk that end up in lawsuits. Yep, that's right, lawsuits. So we're going to look at, some of the top reasons why home buyers, home sellers, and real estate agents can kind of get themselves into trouble. So we're going to talk a little bit about that and some of the ways that you can avoid and mitigate your liability. And then lastly, we're going to talk a little bit about, we're going to kind of open it up to questions. I've got a few questions for Matt, but you know what? I'd love to get questions from you guys. So anyways, with all that being said, I want to welcome to the stage Matt Alegi.
Hey, Kevin. Thanks for having me.
Hey, there you are. How are you doing?
Very good. Thank you.
Did you watch the Redskins / Commanders game on Sunday?
I did. As you know, my lovely wife, who's also a lawyer, was born and raised in Philadelphia. So it was a difficult afternoon here at the House of Alegi, but what a year. What a fun team to watch finally. And sorry it's over, but first time we've been excited about football in January since I left for college in the early 90s.
I mean, the thing that's amazing to me, and I posted something about this on Facebook, is, I honestly, I was just kind of somewhat touched by everything because, I grew up, watching them going to their games. My parents had tickets in the 70s, 80s, up until probably mid 90s or so. And it was just like, dude, like I scheduled everything around. Like when I got the schedule out, I blocked out every Sunday or whatever day they would be playing a Monday night. And it was non-negotiable. People would ask me, hey, Kevin, can you do an open house? Nope. Got an appointment. Can't do it. My appointment was to watch the freaking game and everything. And that just kind of so got pissed on over the last 25 years with the Snyder era. And so what it just shows me, and actually is just that how important it is for leadership starting at the top, culture and all that. It's only been 1 year, but I have to believe that there's just so much different about this year than there've been the previous 25 years. Because a few times along the way, we had a few glimpses with the RG3, like you think you're turning the corner and then you're just crushed the next year.
Yeah, Jaden Daniels is special. And, I think the ownership change and the changes in the front office are good too. It's funny, something that you said, Washington football team and local real estate. One of your office mates was doing a live stream yesterday morning and touched on something that you just said. From the 60s through the mid late 90s, there were not open houses on Sunday in the District of Columbia or in the close-in suburbs. There weren't. Yeah. That's gone away. That's gone away in the last 15 years. The last 20 years, but really the last 15. The NFL hasn't affected Sunday open houses, and the industry experts think that next year that's going to change. No more Sunday open houses. Certainly not within the district, and probably
not in the DMV. Now you're 100% right. I've been doing it. You know, it used to matter when you did open houses, you know, and now it's like, to me, I'd rather do them on Saturday, because you're just getting more people through on Saturday, so people can watch the games on Sunday. But it didn't really matter up until, hell, probably about halfway through this year. So probably after the Hail Mary pass. But
yeah.
Anyways, but so, you know, I wanted to, you know, kind of bring you in here today because you are always on point with a lot of the things that are going down from the legal aspect. Not always the most sexy topics in the world, but you know, you have a way of bringing sexy back to real estate. And so, I mean, you are the Justin Timberlake of real estate law. You're bringing sexy back.
Wow. I hope my wife's not watching this. The Justin Timberlake of real estate.
You know, that's the best analogy I can come up with.
I'll take it.
Anyways, so, you know, it's interesting because, you know, last year we had the whole, you know, in March, we had the whole NAR settlement that occurred with the class action lawsuit. It made a lot of waves, you know, definitely in March, because you got all this clickbait that was coming out that the 6% commission is going away and real estate is going away. I mean, it was just a lot of clickbait that was out there. And then, you know, it kind of died down a little bit because other things happened. Starting in August of last year, August 17th, a lot of the rule changes that came about because of the NAR lawsuit went into effect. And, you know, then you get, you know, that was kind of big back then. And then, of course, you get into election season. You know, we had just a little bit going on there around election season. So it kind of dropped out of the public mindset, I guess you can say. We have the inauguration, we have the holidays and everything. And now, you know, I'm starting to get kind of busy going out and meeting with clients, especially, you know, potential home sellers. And they're asking me a lot of questions like, oh, yeah, you know, wasn't there like something that happened last year, like with commissions and with a lawsuit? And, you know, and so once again, it's kind of like waned for quite a bit. But now, you know, now that we're in spring season, actually, we're starting to enter the spring, you know, real estate market season. I'm getting a lot of questions asked about it. So, you know, why don't we kind of pull up an article? We don't really need to go through the whole article, but this comes from the New York Times. And it just talks a little bit about the settlement that occurred back in March of last year, rule changes that took place, you know, throughout the country, at least locally here, starting August 17th. And why don't you kind of let us know a little bit about the genesis of this and kind of where we are today with some of these things?
Yeah, sure. And just, you know, for your audience, as you said, partner Shulman Rogers, I chair the real estate department. We've got, you know, over 100 lawyers across 4 offices in the DMV here. Most of us are sitting in our office at Park Potomac, right there, Montrose Road, and I-270. And as you know, Kevin, you know, I represent consumers, buyers, sellers of real estate. I represent real estate brokers, title insurance agents, other lawyers who are involved in real estate transactions. So I have this conversation and some of the other conversations you said you wanted to have today with all kinds of different people, you know, everyday folks who are buying and selling houses, and, you know, industry professionals, licensees, brokers, all the way up to other lawyers who do this for a living. I'm going to assume that our audience today is just regular folks, buyers, sellers, consumers, because you can get into, we can get into pretty deep weeds and pretty deep water if we want to. I mean, certainly if anybody, I guess we're live, so if anybody's got questions, they can feel free to ask them. But the general bent of my comments, unless you want to dig deeper, and I'll answer any questions you have, or your audience wants to dig deeper, will be, kind of a consumer directed.
Right.
The NAR settlement. It's probably easier to talk about, we'll talk about the before times and the after times like we did with COVID. Pre Sitzer versus the National Association of Realtors, which was a big class action lawsuit that got brought out in Missouri that caused all of these changes. Real estate brokers communicated to each other the total amount of commission and how much of the commission a listing broker would share with a buyer broker through the local multiple listing services. So anybody who's bought a house or sold a house rather, has sat down at a kitchen table with someone like you, gone through their listing agreement, their brokerage agreement, where they've detailed, okay, the total compensation, here are all the things I as a broker am going to do for you to get your house sold, get you through the transaction, and get the proceeds into your hands. And here's how I'm going to get paid. I'm going to get X% of the sale price as my total compensation. And you understand and agree, consumer seller, that if there's a broker on the other side of the transaction representing the buyer, you're authorized me now, sitting at the kitchen table before I list the property, right, to share Y% with the buyer's broker. If I sell it myself and there's not another broker, I'm going to have to do a lot of work that the buyer's broker otherwise would do. So I'll get X less some percent. But we're going to agree now, say, I'm going to 5%, the total compensation for the sale of your house, on average probably was 5%. You're authorizing me now to give 2.5% of that to a buyer broker if the buyer is represented. And if I sell it by myself without a buyer broker, I'll get 4.5%. Okay. Right. Before the settlement, all of that information about the total compensation that the listing broker was going to receive and the amount that they would offer to a cooperating buyer broker was transmitted into the multiple listing service. The multiple listing service before the internet was really important, but the multiple listing services, if you see MLS in these articles, or Bright is the local company, but the multiple listing services are the broker to broker communication networks that existed even before the internet, where brokers would put in properties that were for sale. So all the other brokers in the area would know what properties were for sale. When they listed a property for sale before the settlement, they would also put into that listing, that advertisement, broker to broker advertisement through the broker to broker communication system, how much a buyer's broker would get paid if they bought a buyer to the property. Sellers in Missouri got together and got a class action lawyer and filed a big class action suit, basically claiming anti-competitive behavior. It was an antitrust, Sherman Act antitrust suit, claiming anti-competitive behavior, price fixing, and also some deceptive trade practices. The buyer's agents were advertising that they worked for free or that the consumer didn't pay anything for a buyer broker services. And the plaintiff's lawyers in that case argued that that was anti-competitive, that was price fixing, and that was artificially driving up the overall price of homes, of residential real estate. They won. They got a jury verdict of $1.8 billion with a B, I believe, under the antitrust statutes. Those get tripled. So, the National Association of Realtors and some other named defendant real estate brokerages, large real estate brokerages, were staring a $6 billion judgment. The result of that were settlement discussions, which, as happens, and what came out of it was a fairly detailed settlement agreement between the class action plaintiffs in this Missouri case, and the National Association of Realtors and the named brokers defendants. The result of which, the settlement agreement deals with a lot of things, including how much the NAR is going to pay and these other brokers are going to pay and how folks are going to get money from that. But the portions of the agreement that made the news and that people are talking about when you sit at the kitchen table now and they say, hey, didn't something happen with commissions? What's going on? Were some agreements about practices that members of the National Association of Realtors would adhere to going forward. The concept that the class action lawyers and the Department of Justice was involved in filing briefs in support and against certain parts of the settlement. But the concept basically was, in addition to the money, you're going to have to change some of your behaviors. And the concept that the plaintiff's lawyers had was a decoupling of the brokerage compensation. So no longer can a broker communicate through the broker to broker communication system how much a buyer's agent can share in the listing agent's commission.
Now, when you say the broker to broker system, you're talking basically the MLS, correct?
The MLS, the multiple listing services, can no longer advertise cooperating brokerage commissions through the multiple listing service. So it used to be we had that conversation at the kitchen table. You're going to pay 5% for the sale of the house. If there's a buyer's broker, I'm going to give them 2.5%. You would communicate that before the settlement through the multiple listing service, the MLS, the broker to broker communication system. Not allowed to do that anymore. Okay. And what they really wanted from a spirit perspective was a decoupling of buyer broker compensation and listing broker compensation. They wanted there to be competition among buyers brokers on price. They did not want the price to be set, the cost of the services for a buyer's agent to be set that had nothing to do with the consumer who was hiring the buyer and their conversation with their buyer's agent.
So ideally, in a perfect world, what they're ultimately looking for is for a seller to pay for seller representation and a buyer to pay for buyer representation. I mean, in a perfect world, that's what they're looking for, where it's just clear, black and white, and there is no compensation, that is either retained or offered from the seller side of the fence, or are you saying more that asking for payment from the seller side is okay, but it all should be in a real estate contract. There should be nothing in MLS. There should be no discussions about it from broker to brokers. I mean, what are you saying? Ultimately is the goal here?
Yeah, and what I see you struggling with is legislation by class action lawsuit and regulatory, enforcement intervention, which is hard to figure out. But yes, it's fairly clear and appears to us. The settlement agreement is clear that you can no longer communicate through the multiple listing service cooperating broker compensation. What it appears that the plaintiff's lawyers and the Department of Justice want is a listing agent having an agreement with their consumer seller for how much the listing agreement is going to get paid for providing services and selling their house, and for a buyer's agent to have a negotiation, conversation, and agreement with their consumer buyer about how much the buyer's agent is going to get paid for providing their services, not let the buyer buy the house. Okay, they want them decoupled. I think in a perfect world, what they all want is for buyers' agents to compete on price, and for those agreements truly to be separate. That's not exactly what's going on in practice yet. We can talk about some carve-outs from the agreement in just a second. But in addition to that decoupling, that no longer being able to communicate through the multiple listing service what a listing agent is willing to share of their commission with a buyer's agent, also pretty key. Buyer's agents can no longer advertise to consumers that their services are free or that there's no cost for their services. Before the settlement, the claim in the lawsuit is a buyer's agent would say, "Don't worry, you don't pay me anyway. I don't cost anything."
Right.
And that was deceptive because the seller paying, the listing broker sharing the commission that the seller was paying the listing broker was driving up the cost of the homes in the amount that the buyer's brokers were getting paid. So they're saying it was free was deceptive. You're not allowed to say my services don't cost you anything anymore, even if you're only getting paid by the seller directly.
Right.
And a buyer's agent now has to have a written agreement with a consumer before they show them houses that details how they're getting paid. And they're really not permitted to collect more than they've agreed with the buyer at the beginning of the process in that written agreement.
Right. So I'm just going to throw it out there. You're probably going to disagree or challenge me on it, and that's fine. Possibly might say that I might get sued. But anyways, don't
say anything that's going to get you sued. Just generally for you and for your public.
Yeah. No. But when I'm out in the field, obviously a lot of the, we talk about when I'm working with buyers, when I'm working with sellers, we're meeting for the first time, we're counseling about these things. Obviously I'm talking about a lot of these rule changes about the fact that there no longer is a field in the MLS that even discusses, compensation. I mean, it's no longer there anymore. And I'm going to say this word, the commission word, which we're not supposed to say anymore. We're supposed to really say more compensation. So no longer is there a commission/compensation field there anymore. But I can just tell you in practice what's going on, and I think what's going on is that ultimately what's happening out there from a buyer's side. I'm having conversations with my buyers before I wouldn't say it's 180 degrees difference, but it's definitely about 90 degrees difference. In the past, I was very clear that they ultimately were responsible for the fee that I charge in representation. However, I think this, it could pretty much be 99.5% sure that compensation amount, let's just call it 2.5% of the sales price, you could pretty much rely on that it was going to be covered, by what would be received from the seller, and would then, the buyer theoretically would bring nothing to the table to pay the real estate agent. That conversation is a lot different today because, ultimately, compensation amounts are all over the place. There's people that are offering 2.5 that they're very openly saying it's not an MLS, but, the conversation that we're having when, a call goes in, an inquiry goes in from me to them, or, they're very clear on what they're offering, or maybe they say, hey, look, we're offering 1%, or, what, put it in the offer, we're open to it, put it in the offer. So I'm hearing things all over the map. So that conversation I'm having with buyers is very different today because I'm preparing them right up front that my fee is X, and ultimately, this is the fee. And, the question is, how is that going to be covered? We can certainly go out and request that the seller pick up all of that, none of that, some of that, whatever. But ultimately, some of that could come back on you, and making them very aware of that. So that's a much different conversation. I mean, it's kind of the same, but it's different. I mean, in the past, I was pretty much telling them chances are 99.5% that, all the compensation we can get within the contract, because within what's offered by the seller, because we see it in the MLS. It's right there. I can show it to you. Okay?
Yeah. No, different markets are different, but I don't disagree with you.
Yeah.
Look, it sounds like you're doing things the right way, and that conversation between a consumer buyer and their broker is a conversation that I think the Department of Justice and the plaintiffs bar wanted to see happen. Hey, I cost 2%. I cost 2.5%. The seller may contribute to that, but we don't know. And if they're not going to contribute, you're going to have to pay me the difference. That conversation is a good first step, and at least what the plaintiffs bar of the Department of Justice wanted, because I think in their understanding is, as you have that conversation, the consumer buyer can say, wait, I can't afford 2.5%. Let's do something else. Let's do something less. And over time, that might drive the marginal cost of all the transaction fees down. Remember, and there is no prohibition in the settlement agreement from a seller directly communicating. They can't communicate through a multiple listing service, but directly communicating, to the consumer public that they're willing to pay a buyer's agent.
Give me an example of how that might happen.
Oh boy, it's very.
How does a seller communicate to buyer agents on their own that they're willing to offer compensation? I mean, I've seen, like, out there in the marketplace, I've seen sign riders that say buyer compensation. I've on the situations where sellers are offering the compensation, I've had them sign something and we place it inside the house, like on a, plexiglass stand next to the brochures that says sellers willing to offer X. So it really shows the buyers and the buyer agents when they're at the house. Is that all cool? Like, how else would a seller kind of make buyers and buyer agents aware of that?
Things that you're describing seem to comply with the settlement agreement. Locally, the Greater Capital Area Association of Realtors are the National Association of Realtors, the local regional association promulgates forms. They have a form. They have a how the commission is going to get paid for them. That's an addendum to the contract. You'll see in practice sellers filling that out when they fill out the rest of their disclosures and leaving them with the sales materials at open houses. You'll see them communicate that way. Right. Seller can communicate to the consumer public, that they're willing to pay some portion of a buyer's agent commission. The prohibition is on the really what Justice and Plaintiffs bar don't want are sharing of the commission. And certainly what's clearly prohibited in the settlement is communication through a multiple listing service or another system that is set up to circumvent that. The broker to broker communication is really what's prohibited.
Right.
And what they think over time, this is going to be market to market. If you're in a tough market and you're having trouble selling your house and you want to get, brokerages and individual agents who represent buyer representative, who specialize in buyer representation, bring people to your house. There's no prohibition on you as a consumer seller communicating that to them.
Right.
The prohibition is on the broker to broker communication and the broker sharing.
Yeah. Hey, so Matt, we have a question from Karen. She asks, who do you think is suffering the most from the new laws?
Oh boy. I'm
realtors.
I don't know. I'm as it relates. Like I'm a lawyer. I'm an expert on the law. That's kind of a policy question. I'm a layperson when it comes to real estate related public policy. A lot of my friends who are real estate brokers or licensees or other folks in the market are concerned that the end result, it appears what plaintiffs bar and the Department of Justice want is for brokerages to go back to selling houses, and for consumer purchasers to find their house on the internet, and for technology companies and other market disruptors to come in and create broker alternative services to help consumer buyers get through this process without paying what, in the eyes of the plaintiffs bar and the government, is too much for a buyer's expert. Okay, if that happens, and that may happen, if it does, the risk to the consumer buyer is, in America, they're making the largest financial decision they've ever made in their life. With the internet as their advisor. All real estate agents are not created equal. The good ones are good. They provide value and they protect consumer purchasers from making big mistakes. That risk has been, it's been artfully articulated by, my friends in the real estate broker and real estate licensee bar in a way that has not made it into the mainstream conversation or made it into the media when this settlement was coming up. That's my biggest concern about somebody suffering. I'm not enough of I'm not a good enough mathematician or enough of an economist to try to figure out in 10 years if this all plays out the way that everybody wants it to, if the marginal transactional cost drops by 1.5%.
Right.
Has good come from this if the American consumer purchaser is spending $500,000 around here?
Yeah.
And that's got to be the low median. If you're buying a house in Montgomery County, Maryland, District of Columbia, you're spending $600,000, $700,000, $800,000, $1 million, and the internet, and a transaction coordination service as your guide is probably that worries me a little bit. I'm not my area of expertise to say confidently whether or not the marginal cost, transactional cost coming down 1% or 1.5% over 15 years is worth that.
I'm going to just jump out there for a second. When Karen asks, who do you think is suffering the most from the new laws? I mean, to be quite honest with you, it's been 6 months now since these new laws apparently, or rules, have taken place. I think it was August 17th of 2024. My take right now, and I haven't seen it personally, but I haven't. I think the person that gets really hurt the most during this is potentially that first-time home buyer who's barely scraping together enough for their down payment, their portion of the closing costs. I mean, heck, unless they're VA eligible, and maybe they are, but if they're not, most likely, they're going to be putting down at least 3 to 3.5%. So let's say that's a $400,000 house. You're looking at $12,000 to $13,000, $14,000 there simply for down payment. I always tell everybody that, that closing costs, and especially in Montgomery County, Maryland, are going to be probably about another 3.5%. So, your average first-time home buyer, just to put a 3% down payment, cover their end of the closing costs, you're looking at $25,000 to $30,000 there. Now, all of a sudden, hey, you know what? Sellers may not offer compensation to the agent, and I may need to come out of pocket with that, which could be another, whatever that is, could be anywhere from 1% to maybe 3%. I mean, that's, a lot of times that's what breaks the bank and makes it impossible for them to be able to compete, as if they've already had a tough enough time. A lot of the first-time home buyers competing with, the amount of investors and cash buyers who are out there in the marketplace right now. So, Karen, I would say that the person that's going to have the toughest time, unfortunately, a lot of times it's the ones that they try to protect the most, which is going to be the first-time home buyers and those people that are, trying to crack this market. I mean, it's a tough market to crack. It was already, but if they're going to have to come up with an additional 2.5% to pay their agent, that just, a lot of them are going to get priced out of the market there.
Or if this runs its course and the end result that we think the plaintiffs bar and the Department of Justice wants to come to pass comes to pass, which is buyers aren't really represented. Yeah. They're filling out their forms online and having a lawyer look at the contract. The other potential unforeseen consequence, Kevin. Do you want to talk about clear cooperation at all? I mean,
you know what? I want to get you on another time to talk about that. I was kind of I wanted to discuss that. That's a big topic, especially with us at Compass. So, but you know what? Let's save that for another time, though.
Really briefly.
Okay. 2
seconds. So your consumer audience understands. One of the multiple listing service rules basically require a real estate agent, when they get a listing, they have to put it into the MLS, whether the cooperating commission, put all that aside. But there are rules in place now that require real estate brokers to put into the multiple listing service every house that they have been asked to sell by the consumer public. I have concerns. I have some concerns that if the plaintiffs bar and the department, if this all goes, the way that the plaintiffs bar wants it to go, there will be a degradation in the multiple listing services generally, and a degradation of clear cooperation, which to me is just a huge fair housing issue. If properties aren't going into the multiple listing, if there's no guarantee that there's at least one repository where your house is going to be sold, and you're relying on individual private broker networks for consumers to figure out what houses are for sale, that seems to me like a recipe for blockbusting and redlining. And I saw yesterday Zillow. Now, I have not looked at the methodology of Zillow's study. Zillow did a study about private broker networks as opposed to clear cooperation. In other words, now that the multiple listing service doesn't serve what used to be critical function of communicating compensation, more brokerages are considering private broker networks and just advertising within the brokerage properties they have for sale instead of putting them in the multiple listing service. So there's no guarantee that there's a central repository where all of the houses for sale are for the consumer public to review. The result of Zillow's study was that of Black and Hispanic home sellers, 75% of them were being offered private network, whereas non-Black and non-Hispanic, only 25% of them were, which is already an indication that maybe there are going to be some unforeseen consequences. It's definitely interesting times for what you do for a living.
Yeah, well, and so I'm going to book you for another Tuesday over the next month. We'll talk about that.
Sure.
So, and so Erin asks, and I think she's asking about the, going back to talking about the NAR settlement. How do you anticipate this will impact the price of the house?
I mean, that's more of a you question than a me question. Clearly, the plaintiffs bar and the Department of Justice think that the breakup of the anti-competitive communication of cooperating brokerage commissions is going to result in the overall compensation to the real estate brokers coming down, and that's going to be reflected in home prices. I'm not so sure.
So my take on it is, I think it's going to depend a lot on the market that you're in, and what's interesting is, of course, we're in the DC marketplace, and right now the DC market area still is very heavily seller favored. I mean, it's not like it was in 2021 or 2022, but definitely there's inventory's low, demand. There's still more buyers in the marketplace than there are sellers. And frankly, right now, I don't think it's going to matter one iota. I mean, sellers are going to get what they can get. They're going to try, and their goal is to obviously try to get the cleanest contract they can, the best qualified buyer and net themselves the most amount of money with the least amount of inconveniences. And right now, when you've got 3 or 4 or 5 or more people bidding, I don't think, I really don't think the amount that's either being offered or not being offered, in the way of compensation is really going to matter one iota to them. I don't think they're going to say necessarily like, oh, because I'm not paying, let's say 2.5% on this, I'm only paying 1 or I'm paying 0, that we're going to sell our house for any less. They're going to get the very best that they can get. So I don't really, my opinion, I don't think it's going to affect the value on prices in a market like we kind of have currently in the DC area. Now, I realize in other parts of the country, the markets aren't exactly the same. And I'm hearing a lot of areas where, you're definitely seeing the tide shifting. When the markets do change here, and as they do, and they will, and inventory creeps up and demand slows down some, I can see that being more of an issue, potentially one that's affecting, price more. I told you earlier when we were talking, it's like having worked through that market, like, and people love to talk about 2008, but that market started changing in 2005. It was like summer of 2005. I'll never forget it. So 2006, 2007, I knew we were in it already. But let's just say from 2006 to 2012, I mean, there are times where it's just like, I would have taken a freaking contract written on a napkin, tape a quarter or dollar bill for earnest deposit, and let's rock and roll with this thing. And today it's obviously much different. I mean, right now it's for home buyers right now, it's such a beauty contest, in that you've got to have the highest earnest deposit. You've got to be competitive on price. Oftentimes it means waiving contingencies that you may or maybe you shouldn't be, but it's being done. So to answer the question Aaron has, I don't really see it affecting too much right now. And it's really early on, but I can see it potentially in the future. So.
Yeah. And not with the, we're not building enough houses to keep up with population growth. I mean, from a comparative, forget all the other macroeconomic factors, might it reduce the prices of houses a little bit? It might. But I don't think it's going to affect the.
So Radic asks a question, and this could take another probably 30 minutes of time, and I don't want to do that because I do want to move along. But his question is, do you? Because I already know your answer to this.
All of my clients do, especially the real estate licensee ones that I have to castigate on a daily basis.
Do you foresee more lawsuits arising due to confusion around the new buyer broker compensation practices?
I foresee more lawsuits. I don't know if I foresee more lawsuits, based on confusion. I think is generous. Look, real estate agents are people. There are good ones, there are bad ones, just like anything else. This is a real shakeup to the industry, and I know Kevin does things the right way, and he's compliance minded, as all of my licensee clients are. There are some cowboys out there who are trying to work around the settlement and find a way to make business as usual. These things aren't going away. The change in the administration might lighten up some of the federal regulatory enforcement and oversight of it, but the plaintiffs bar, the class action lawyers, state and local regulators, they're not going anywhere. There will be more lawsuits. There will be more class action lawsuits. There will be other lawsuits related to violation of the terms of this agreement. Folks are going to try to find workarounds that don't work, and they're going to get caught.
So Matt, I'm going to go out. I'm going to make a statement, and I've said this on many of my videos. And once again, because you work with a lot of other realtors, you represent other brokerages and other realtors. So, you might want to say no comment to this, but if you feel like this is a good statement, chime in. I say on all my videos that 80% of the realtors suck. And I think I'm being generous on that, because I actually think it's closer to 90, but, what do you think about that?
There's the 80-20 rule or the 90-10 rule. I think there was a national news story yesterday that in 2024, I think 75% of the real estate people with a real estate broker or real estate sales license, 75% of them did zero business. Mm-hmm.
Yeah.
I don't think it's anything new that there is a cadre of outstanding advisors who are in that top 15, top 25% of licensees who are providing good value, who are really doing the work, who are great advisors, and there are a lot of licensees who are just part-timers. Now, there are people who are starting out, there are people who are learning, there are people who are taking breaks, but
I might be taking a break after this live stream, but
not everyone who owns a real estate.
But it'd be a short one. It'll be for about a half hour. But anyways, so you know what? Let's transition a little bit. I think we kind of beaten this up enough, and obviously there's, as you've stated, there's going to be more to come, and so hopefully you will come back over another visit. But let's talk about the next segment I wanted to talk to is about, you see as a real estate attorney, you see a lot of things come across your table, your desk there, lawsuits, things like that. And so, obviously we're in an extremely litigious society. We are also in an extremely litigious area, being around the DC area. So what are some of the top things that you see that come across your desk that could be avoided, and how to avoid, getting yourself into hot water there, both as, home buyers, home sellers, and even real estate agents themselves?
Well, home buyers, home sellers, and real estate agents is probably different, but it's like the hit list of things that of lawsuits, disputes, regulatory actions I'm seeing on the home buyer, home seller side. Numbers 1, 2, and 3 call them buyer's remorse cases, latent defect cases. So number 1, I call it buyer's remorse, latent defect. Number 2 right now is probably wire fraud, believe it or not.
Oh, wow.
3, internet tax advice disasters. How about that? Those are the 3 things. And pretty, like perennially, at least number 1 and number 3, called buyer's remorse or latent defect cases, and internet advice tax disasters. That's almost every year for the last decade. I'm in my 20th year at Shulman Rogers, so I've been a real estate lawyer for a long time. I was in the title industry before that, and pretty regularly, buyer's remorse / latent defects and internet tax advice disasters are probably the top 2. The wire fraud, which is very scary, has crept in, in the last 3 to 5 years, and really is getting scarier the more convenient everything, including buying and selling a house, is getting, where you can do it from your phone. The more money gets stolen out of the transaction. But that's kind of a new one. But the first and the third are pretty perennially, regularly.
Can you give me an example of, because, at Compass, we have a wire fraud, basically disclosure that we have all buyers, sellers sign, and it basically says, it makes them aware of wire fraud. It states that, neither I nor Compass will ask them to wire us money. But can you give me an example of something you've seen? Because I've heard a little bit about it. Thank God, I've never been a part of any of this. But can you give me an example of something you've seen out there that people might be aware of?
The textbook one that comes across our desk is usually, unfortunately, the buyer. Title company or lawyer or real estate agent sends one of their buyers who gets to closing, and the money that they wired just isn't there. This is an industry, in China and Eastern Europe. There are people who put on suits and go to office buildings where their job is to, be hackers and steal money from international people. The fact pattern of the big wire fraud and what they're stealing almost always is the wire for all of the the buyer has to bring. Buyers are borrowing 75 or 80% of the purchase price. They've got to bring the other 20. Okay, usually that other 20 is being transmitted to the escrow agent or the title lawyer or the settlement company by a wire transfer. Okay, and when we get brought in is, buyer gets communication from someone they think is their settlement lawyer or their title agent or their title insurance company, that says, hey, sorry, wire instructions changed. Please send your wire here. And it's really, it's really some hacker sitting in Russia. In the cases, usually the hackers are in, they're usually getting in through, they're not usually getting in through the title insurance company. They're not usually getting in through the settlement lawyer. They're usually getting in through, a professional who's copied on communications that doesn't have adequate internet security or isn't using a professional internet service provider or email provider.
Right.
And they're just sitting and watching. They're involved in the transactions at the beginning. They're hacked into the emails of a lot of different professionals, and they're getting really good at writing emails and watching email traffic. So the hacker is usually in there on day one when the contract gets.
Wow.
They're usually watching early on. Okay. And they're watching the communications go back and forth through somebody who's got an unsecure email who's being copied on transactions. And they'll get the initial communication from the title company or settlement lawyer through somebody else, take the letterhead, get artsy and craftsy, put different wiring instructions on it. And then the day of settlement or the day before settlement, as the emails are flying fast and hot and heavy, we'll send it, oh, hey, with the, high importance, red exclamation point Outlook email that beeps on your phone special. It's
right.
Like, hey, sorry, last minute change. If you want to get this closed tomorrow, you got to wire it to this account. It'll be on the letterhead that's been arts and crafts. And really sophisticated people, have made that mistake and sent that money to the wrong place. And if you don't get on it,
it's gone. I mean,
unfortunately, it's like getting robbed on the way back from the bank. Unless you if you get on it quickly, if you get on it quickly, there are some things that you can do to get it. The payee is always the wrong. The check, the wire still goes to, Jimmy's Title and Escrow LLC. The account holder is never the right payee. So if you're fast enough, and if you can get to the intermediary bank before that money is then resent somewhere else, right, there are things that you can do if you get on it quickly to stop it and try to recover the money. But I mean, you can Google this when we're done. But I tell you, it's from 2 years ago to 6 months ago, we were getting this call twice a month. War was real. The money was gone. Please help us.
Wow. Were you seeing it more with older people, possibly, who are, not real sophisticated when it comes to email, when it comes to potential scams, things like that, because like I do a lot of work with, with elderly people that, being in my 50s myself, I'm doing a lot of work with the generation, ahead of me. And, usually it's, people my age, it's my peers who are referring me to their parents and everything. And when I talk to them about this wire fraud, document that they need to sign, the kids are usually like, Mom, just don't respond to anything. So, I mean, are you seeing it more with like potentially elderly people? Are they more of a target, or is it really anybody?
Victims are coming in all shapes and sizes. I mean, I'd have to go back and look to see how many, we're technically senior citizens, but you'd be surprised. So the social engineering that hackers, phishers, call them what you want. It's not the Nigerian Prince letter anymore. They're getting really good at the communications. They're getting really good at hiding the email address that it's coming from, and the social engineering about when from a timing perspective to do it.
The cadence.
They're getting really good at it. Now the industry's getting very well educated. After having some losses, the industry's getting very well educated about it. So as you said, the consumer's being educated a lot more clearly by the professionals who are involved. Right. Don't send a wire unless you call me at this number that you have now. We're going to have a face-to-face conversation before you hit go on the wire. Bring a cashier's check a couple days before, like the olden days.
Yeah. So you would recommend that. So actually that leads me to a question. So Craig asked the question, what happened to allowing good old-fashioned cashier's check? Is there more fraud with those funds?
The problem with good old-fashioned cashier's checks is they don't exist anymore. And a cashier's check that you take from your bank now and present to another bank isn't good and ready funds. They can be recalled, within a significantly long window of time. So right. I agree. I'm a big fan of the cashier's check or the bank check, the new cashier's check, new bank check. For the most part, we can get into some weeds if you want to. For the most part, it takes about a week to clear and have the bank that it was drawn on confirm to your title agent, escrow company, settlement lawyer that the funds are good. But I'm with you. 2 weeks, if I'm buying something for $1 million or $500,000, to get a cashier's check 10 days before closing and bring it over to the title company and say, here you go. It certainly takes that other problem out of the equation.
Yeah. So
the problem is they're not available same day funds, and your escrow agent can't pay your seller with funds that could be recalled by your bank.
Right. So pivot just a little bit here. So let's talk a little bit about, like, from the seller's side of the fence, home sellers. Do you get things that come up from time to time on disclosure or let's just say lack of disclosure that comes across your desk a lot? I mean, tell me a little bit about that.
That's the biggest claim that we see right now. As you said, it's a litigious country right now. Everybody in the DMV is a lawyer, who's not a real estate agent or financial advisor.
Right, I thought they were all real.
So just people get upset and they sue each other, which is crazy, right, because it's really expensive to sue people anymore. But the undisclosed latent defect, consumer buyers don't realize they're buying a used house. You hate to say used house, but that's what it is. They're not buying a new house, and a lot of people buy houses and get in them and say, okay, great, perfect. We're going to do the downstairs bathroom, and we're going to take that old 80s paneled basement finish out and do a new finish. And as soon as the walls come down, there's mold. As soon as the walls come down, there's a water line. As soon as the walls come down, insert problem that they couldn't see when they were walking around the house. And a lot of times we'll see lawsuits filed for those things. And they are avoidable. The disclosure, it's easier to talk about in Maryland, disclosure requirements. So these latent defect cases are really hard to bring. They're hard to win in Maryland. In the olden times, like 30 years ago, Maryland was like, most of the country and most Anglo-American legal systems throughout history. It was a very buyer beware system. The court systems can't hear lawsuits about every single thing. So they had some hard and fast, some thought unfair rules. But right, if you're going to buy something big and expensive, it was your job as the purchasing consumer to do your research and do your inspections and conduct your studies and to figure out everything you could about the property. And once you bought it, you're the person in the best position to figure all that stuff out. Once you bought it, it was yours. Caveat emptor, buyer beware, right? Maryland changed all that by statute, over 20 years ago, and said, yeah, fine, buyer beware, but consumer seller of real estate, you have to disclose a latent defect of which you have actual knowledge. So right, statute's long. Again, we're going to be consumer minded here today and not licensee minded or lawyer minded, but a latent defect in Maryland is a physical defect with the property that a normal person just wouldn't see on a visual inspection walking around the house that could cause actual harm to a human. Okay. So when you teach this class to the licensees, if there's a gaping hole in the second floor hallway and you throw a carpet over it, that's clearly a latent defect. Somebody can't see it. They're going to walk over the hole. They're going to fall. They're going to get hurt. That's an easy one. There are harder ones, relating to mold and moisture and, seasonal wasp. There's a gamut of things. What is it, a latent defect or not? But,
the one
person wouldn't
that I come
recognize on a visual inspection, cause harm to a human. That's a latent defect. You have to disclose those, but you only have to disclose ones that you have actual knowledge of. Okay. Yeah. When they passed that law, they also charged one of the agencies with creating a disclosure and disclaimer form. So now Maryland has a 4-page form where you've got to disclose your latent defects. You can also choose to either fill out the form and make the state standard disclosure, which is a check the box. Does moisture, does water stand on the property 24 hours after a rain? Do you have any electrical problems? Do you have any roof leaks? Do you have air conditioning? If you have air conditioning, is it provided? It's this check the box. Do you tell us everything you know about the property? You don't have to fill it out. You can say, I'm not doing it, I'm disclaiming, and then just disclose latent defects that you know about and move along. We see, a lot of the claims that we see, instead of disclaiming and writing down latent defects that people knew, there's, I don't want to say cuteness around the edges, but there are some cases that we've seen where people would check off, I'm not sure, or they had water intrusion in the basement that they remediated fully and haven't had a water problem in 5 years. And they check off, no, I don't have water intrusion in the basement. And that's how it's worded. And that's the correct answer, factually. I haven't had a problem in 5 years. There's no present problem with water. Whereas just thoughtful completion of the disclosure form. Real estate sales are an emotional business. People fall in love with houses. They want houses. And at the beginning of the process, the buyers can get over a lot of warts. In 99% of the cases that I've had that weren't latent defect cases, but were, a misdisclosed defect, you checked, I don't know on this when it happened, or you checked, I don't have a problem with this when you should have known that you did, could have been preempted even earlier in the process by a seller just filling out that form, just over disclosing. Because the over disclosure is not going to scare off a prospective purchaser, especially in a market like we've had here in the pretty long recent past, where there's not a lot of inventory. There are more buyers than there are sellers. I would go out of my way to over disclose. Do you have a problem with the roof? No. Had the roof replaced, a year ago, or had the roof partially replaced a year ago. Before that, I had some water issues. The language of the disclosure is present tense. I would over disclose the repair 5 years ago. I'd over disclose the replacement. If you over disclose, you can almost never go wrong over disclosing, because if you type it in that pre-printed form, nobody cares.
I 100% agree. I mean, first of all, that's seller protecting themselves. It's also being, completely transparent to the buying public. And what's interesting is I see, because I work with both home buyers and home sellers. I mean, I know the discussions that take place, beforehand, before the home goes on the market, before the buyer's going out to see the first home, and you're kind of discussing those things. And I think that, especially these days in a time period where there's just so little transparency, I actually think that over disclosure goes a long way and actually builds trust with the buyers. Because I get that kind of stuff all the time that you'd mentioned, hey, the roof doesn't leak now, but 6 years ago, we had the derecho come through, and this happened and that happened. And then we did this and we did that. I've got the invoices for it, and we haven't had a problem since. You know what? Let's put that down.
It takes the emotion out of it. When the water comes in through the basement door and you click and you checked off, I don't have a problem with moisture. The buyer goes, that guy lied to me. Whereas if you checked off, yes, we've had problems. The drain at the bottom of the stairs clogs after a heavy rain. We've had it replaced a couple of times. Keep an eye on it.
Yeah.
Nobody cares when they're coming to buy your house.
Right.
They don't go, oh, I'm not buying it because of the stair drain. They say, well, we'll deal with that. And then when it leaks, they don't feel so emotionally charged about having been deceived.
So what you would say to home sellers is disclose, disclose, disclose.
Disclose, disclose, disclose. I mean, to me, in this market, this is a market dependent thing too, but in this market, I would over disclose. Anything that's close, there's no reason to get cute.
Right.
If you've disclosed it, you've taken all the teeth out of the buyer's case. So the actual latent defect cases are really hard to win on. They're hard to prove. People still bring them, but you have to prove, with a latent defect case, what we were talking about was you fill out the form wrong, or you fill out the form incomplete, or you fill out the form presently true, but 10 years ago something, and they they can maybe get in there and get past motions and make you spend a bunch of money in legal fees. The latent defect cases are so hard to.
It's like you almost
take on a buyer side because you almost have to catch them
on video, like lying about it. Like, yeah, we're going to put down this, or it's almost like you need video.
Had a case once where the seller disclosed no water, no mold, and the Lowe's Moldex paint they left under the stairs in the storage space, and it had the receipt taped to it with the date on it.
Dude, I think that was
that was the only time I got a latent defect case. And I think
that was my transaction.
This one I like. I like this. But yeah, proving actual knowledge is very, very hard.
So I'm gonna ask one last question. We're running a little bit low on time here, but one of the questions that I get a lot, and we were seeing this happening before the pandemic, but obviously once the pandemic occurred. So I get a lot of questions from home sellers and home buyers are, can I just DocuSign my closing? Because of course, when they're working with me, typically sellers, buyers, the majority of the paperwork and the documentation we're doing is all via electronic signature. And so, I get that question a lot, like, can I just DocuSign it? And so what would you say about that? What are some of the changes that are occurring? Because obviously with COVID, we're starting to see more remote closings, virtual closings, but will it ever be as simple as DocuSign?
I mean, here's to hoping not. Look, COVID changed a lot. Still, wet signature, Fannie Mae and Freddie Mac, who guarantee most of the mortgage money in the United States, required wet signatures witnessed. Okay, that should tell you something about wanting wet signatures witnessed. With remote online notary and other things, you can do a lot. You can finish a lot of the process without sitting in person with anybody. Okay, there are the insurers, the title insurers mostly, are starting to crack down on remote online notary and when they'll allow it and when they won't, because with AI and deep fakes and how it's getting really scary, how easy it is to impersonate somebody else, even in a remote online notary setting. But it's the practical aspect of it to me, Kevin. When I sign things by DocuSign, like my credit card contract or the end user license agreement to some piece of software that I just bought that's 150 pages. Do you use DocuSign, Kevin?
Yes.
How likely are you to read on your iPhone a document that's sent to you by DocuSign that's 25 pages long?
Next to zero. I mean, I might send it to you, but I probably I'm probably not going to.
You're going to spend the most money. The biggest financial transaction of your life.
Right.
Take the afternoon off. Show up, read the papers, and sign the documents with your lawyer. But yes, look. Will you be able to do all of this by your phone? In the not too distant future, probably. And can you do a lot of it via DocuSign or electronically now? Yes. And remote online notary is making it even easier for documents that you used to have to sit in person with the notary public and swear and have them stamp and witness you in wet ink. Even that is getting easier to do electronically and remotely. I like convenience. I'm Gen X. We're the Mendoza line for being tech unsavvy dinosaurs. But I want convenience too. But spending $1 million, spending $600,000 to me,
day off.
It off. At least it'll make you read the papers. But yes, it's getting a lot easier to do, and in the future, in the near future, might be possible to do pretty well electronically. I don't think it's a great idea.
Yeah. So Matt, I think we're winding things up. I mean, why don't you tell people here, anybody watching, tell them a little bit about, some of your specialties and what the type of business or the type of law that you're interested in. If anybody has any legal questions or things that come up down the road.
And look, Shulman Rogers is a full service law firm. We've got over 100 lawyers. We really are, full service, personal and commercial, all over the DMV and with some of our practices nationally and internationally. I'm a real estate lawyer. Most of my time is spent representing buyers and sellers in high-end residential and commercial real estate. My partner, Ryan Mallett, as you know, runs the firm's residential settlements department. So, we do house closings too. And at a law firm, because of the way that title insurance is regulated, 90% of the fees you're paying at closing are the same, whether you're using a law firm or you're using a title insurance agent that's got a notary public stamp and a GED. So, we've got that business too. Most of my time is spent helping high net worth clients, buying unique residential properties or commercial properties, and, as you know, representing real estate licensees. I spend more than half my time representing real estate brokers, real estate agents, title insurance agents, and other lawyers involved in real estate transactional practices with their day-to-day operations, regulatory compliance. There's an alphabet soup of things that you've got to be careful of when you're a real estate professional these days, and when they get in trouble. I represent real estate licensees in front of the Real Estate Commission here at DPOR and the ISB, and title insurers if they get into issues with consumer protection problems or the insurance administration.
Well, I really appreciate more reaching out to you just as a friend, but it's always good to know that, and like I say, and I've sung Ryan's praises, your partner, plenty of times, because he, you and he both have helped a lot of my clients when we've been in binds, had questions that have come up. So, I want to thank you for that. And I'm going to kind of wrap up. I just wanted to let everybody know I appreciate, everybody watching. I appreciate the questions that came in. I'm going to be doing this again next Tuesday. I don't have a guest, so I might lure Matt back in, possibly. But anyways, I wanted just to kind of remind you all, if you have any questions about real estate, you want to reach out to me, you want to discuss things one-on-one, you can go ahead and click on that or scan that QR code. I see two of them up there right now, but scan the QR code, and there you can actually set up a one-on-one Calendly, or you can set up a Calendly appointment with me where we can set up a video conference where you can discuss anything about real estate, your situation one-on-one. Be happy to do that. And you can also reach me. The easiest way to really get me too is by text at 240-793-7495. And continue to check out and support my YouTube channel. If you like the content that I give you, go ahead and like, subscribe, share that information. And once again, guys, I appreciate everybody watching. Thank you once again to the president here, and Kevin Grolig, and I'm signing out.